You can represent yourself in a restraining order hearing and win, even when the other side has a lawyer and you don't, but with a few caveats. In this video, I'm going to be giving you tips on how to deal with that opposing lawyer. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I am also the creator of a course called Defeat the DVRO, in which I teach you how to represent yourself in your restraining order hearing and win. If hiring your own attorney is just not a possibility for you for this case, and you know you are going to be representing yourself, then my course is for you. You can get your link to your free first class down below. And this video is for you because I'm going to be giving you some easy tips that I guarantee are going to make it easier to deal with that other attorney. Okay, so let's jump right in. I suggest only communicating via email. Be polite and don't let them bait you. Do not send anything angry back. Basically, expect everything that you send to ultimately go in front of the judge. And if you are the respondent, you do not want to seem like an angry, out of control person. The last thing you want to do is generate evidence against yourself. If you're the petitioner, you don't want to seem like you are actually the problem. If the other side has an attorney, expect to be cross-examined in court. Cross-examination is where after you give your statement and your testimony, the other side gets a chance to ask you questions. Now, I explain how to do this to the other party in the course. And look, if the other side has an attorney, they're going to cross-examine you. They're going to try to poke holes in your story. They're going to point out, let's say that you are the petitioner and you claim that you were hit in the face, but you didn't take any pictures until 3 days later and didn't report it until 3 days later. I'm going to point that out in the form of asking you questions on cross about that. You claim that my client hit you in the face, and that was on January 1st, but you didn't report that until January 4th. You didn't take any photographs during that time. You didn't report it to the police. You didn't report it to anybody else. You just kept it to yourself until January 4th. And in between, I'm making you say yes, right? Because that's all you can kind of say. Until finally, on the 4th, you claimed that you had been abused. Now, I mean, you can see why you need to just stay calm here, right? Because I'm sure being asked that, if you were actually the victim of abuse, is maddening. Maybe you were embarrassed. Maybe you were trying to forgive the other person. There are so many reasons why maybe you didn't report it until a few days later, but as a defense attorney, it's my job to point all of that out. So do not get triggered. Just answer briefly and only clarify if needed. If the other side's attorney knows what they're doing, you are probably going to say yes to a lot of things that maybe you wish the answer wasn't yes. Just do it. Do not try to make excuses. Do not go on and on. It is just going to make you lose credibility with the judge. Be prepared. Make sure that you know how to get your evidence in, understand what objections they can bring up. Hearsay is a common one. Lax foundation is another one. These are things that require a longer explanation than I can give in this video, but I do teach this in the course, and I teach you actually how to object to the other side's evidence. And that's something you can definitely do if they have an attorney. I can't tell you how many attorneys I've had actually just withdraw their evidence when I objected, when I knew what the obvious counter argument was. So still use them. A lot of attorneys are kind of lazy with restraining order hearings too. They just sort of figure, well, both sides will tell their story. The other side doesn't even really have an attorney, so I'm not going to do that much. Okay, if you take the course and you do everything in the course, you'll probably do more than most attorneys, and you will probably catch them off guard, which is very fun. Use the fact that you do not have a lawyer and get to just tell your side of the story to your advantage. When you have a lawyer, typically how your testimony is presented is that the lawyer asks you specific questions and you give an answer. And so the lawyer can sort of control the narrative and make sure that you're not getting into things that you shouldn't be. But when it's done in this format, which is generally required by the court in this situation where someone has an attorney, sometimes if the attorney doesn't do it well, then it lacks a cohesive sort of start to finish story, right? Of here's what happened, here's my side of it. So you, as somebody who does not have an attorney, the way that your testimony is going to be presented is that you just tell it to the judge. Most people fail here because they start talking about things that are not relevant, because they go on for too long, because they get lost in their own thoughts. If you can give a succinct, chronological, if there are multiple dates that are alleged here, explanation of what occurred to the judge, then you are going to look really good. And if the other side and their attorney didn't do a good job getting the story out, and you focused on what was important and got all of that out within whatever limited amount of time, then you have used your ability to tell your story without questions interrupting it from your own attorney to your advantage. I hope you found this video helpful. And again, if you are thinking about representing yourself at your restraining order hearing, you can keep binge watching YouTube, hoping to find the answers or get them delivered to you on a silver platter, which is exactly what I do in my course. If the other side has an attorney and you don't, and you show up prepared, ready to make objections that actually could keep even evidence the lawyer is trying to use out, and ask the other side questions, and you know what the judge is looking for, you have such a great advantage. I mean, one rule I always follow is never underestimate your opponent. And I apply that even if the other side does not have an attorney, because you never know, they might show up prepared, but most attorneys don't. If you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.